Hi everyone, welcome to another episode of TaxSnax. My name is Shanzé Shah and I'm a barrister here at Old Square Tax Chambers. Today's going to be a short TaxSnax episode about a recent judgment in the First Tier Tribunal, and this was in the case of Moran, so Moran and HMRC, and it was just recently this month, a few days ago, around on the 15th of May. The case addresses some really interesting points on the transfer assets abroad regime and rent-free living. It's been a problem. It's been a matter that has been going on for a while, and to not give away the ending, but essentially the appeal was dismissed. So let's go over some key facts of what was the background of this case. So we have Anne Moran, who lived rent-free in the UK in a UK property in the Highlands called Highlands, which was valued at around 2.7 million. And the property was held by a company called Namib Limited, which was a Jersey company, and it had no independent income. So Namib was funded by interest-free loans from another company called Watcher Limited, which was also Jersey-based. And then it was Watcher, as you can see, it would be useful if we had a little diagram here. Watcher was owned by the Blessed Trust, which was an offshore discretionary trust, which was settled by Mrs. Moran's late husband, who had died a few years ago, Mr. Vincent Moran, and that was settled by him. So he had Blessed Trust, and Watcher was owned by Blessed Trust, and then you had the property, which was held by Namib Limited, which had no independent income. So essentially, HMRC in this matter argued that Mrs. Moran's benefit rent-free accommodation and funded maintenance had triggered a income tax under the transferred assets abroad regime. And the disputed years that we're talking about are from around the tax years 2012 to 2013 to 2019 to 2020. So the legal framework was obviously addressing sections 731 and 733 of the Income Tax Act 2007. And so the key issue was whether a charge arises under the Income Tax Act 2007. And then you have in the judgment, in paragraphs 28 to 30, the key issues are sort of listed out. And within that, the appellant had brought forward the three main points. So the appellant had said that the provisions don't apply because the accommodation benefit was not provided out of the assets which are available for the purpose as a result of the transfer or one or more associated operations within the meaning of section 732 subsection 1 C. And then if the provisions do apply, then they wanted to raise the motive defence, which I'll talk about later, under section 737 of the ITA, or under 739 and or section 429A applies because condition A in each of those is satisfied. So it's worth reading the provisions just to get a deep understanding if this is an area you're looking at. And then they said, if in any event a charge does arise under 731 to 733 ITA, that constitutes a restrictions of directly effective rights under Article 63 of the Treaty on the Functioning of the European Union. And then they said, in that, the motive defence forced to be subjected to a conforming construction to the effect that tax avoidance is understood in a sense of artificiality, and the transactions in this case satisfy the domestic legislation when interpreted in that matter. So, and then they say, whilst they had these 3 points, they also had 2 further grounds that if a charge did arise, the conditions for making the discovery assessment by HMRC were not satisfied, and or that the assessments were made out of time. Specifically, they said that for the years 2012 to 2013, and that in 2013 to 2014, the assessments made on 3rd of April 2017 and those made in 2018. And then in relation to penalty assessment, there's obviously penalty assessments. They said that the appellant was actually not careless, and But they weren't, these two little grounds were not expanded on within the appeal and kind of followed through from everything else that we'll go through. So just kind of a recap, you have 731 to 733, which we're looking at. And the first year tribunal took sort of a purpose review. They said that the income used to maintain a property in the UK occupied by UK resident through offshore vehicles was within the scope of these provisions. So the accommodation benefit, sort of looking at in like a broad brush review, the tribunal found that Mrs. Moran's rent-free occupation alone constituted a taxable benefit. So, and it said that the entire sort of residential experience, by which I mean sort of the roof repairs in the house, hot water, basically the management and runnings of the house, pool key cups to boundary trees, whatever, was part of the accommodation benefit. And then funding for these came from Watcher, so the company I mentioned at the start, via NMIB, which was the other company, and that was using offshore income. So the tribunal adopted a sort of a common sense test, and it said that benefit wasn't just access to the building, it also included, sort of preserving the fact that the building was something that you could live in and its amenities. So that kind of fell through. Then you had the motive defense, which basically said that, the motive was not tax avoidance when this was set up. And she said that, that's not the aim. Mrs. Moran said that wasn't the aim of the structure. And as under the motive defense sections, one must ought to show that the avoidance was not more than incidental, and they must also show that the avoidance was not purpose at all. And essentially in this case, they said it was quite hard to prove. First, it was a lot of years on. There was not any complete records, and we also had Mr. Moran, who'd passed away, and essentially the appellant had failed to discharge the burden. There was possible evidence to suggest that this was possibly to avoid tax was something that was considered, because there was some conflicting evidence about why the structure was actually created in the first place, and then there was a lack of essentially evidence to prove what was the motive of it, and just by saying that is not what she intended was just basically not good enough to satisfy the motive defense. And then they also went on to say, the discovery assessments that were raised in the 2013 and 2014 were not valid, but the tribunal upheld them, and they'd held that Mrs. Moran had actually failed to declare the benefit. And whilst she might not have known about the assessments, that was by her own carelessness. So she did have enough information to sort of trigger disclosure, but she did not take the responsibility to do so. And the fact that FTT kind of accepted written evidence and contemporaneous letters as sufficient proof of the discovery, and Mrs. Moran has essentially failed to declare the benefit. And then as you see, one by one, the FTT essentially dismissed all the grounds and didn't allow the appeal, and it was dismissed on sort of all points because it kind of points out some key factors. I think one of the key factors it points out is when you are going for the motive defense, there ought to be substantial information and evidence, whether that's written evidence or mostly written evidence, witness evidence, to kind of prove that was the key for setting up a structure ought not to have been tax avoidance, and that really there was another intention there. So there is strong preference for sort of documentary evidence, which really was not here. And in the terms of the discovery assessments and alleging that there was not sort of their validity, one ought to take responsibility when these things happen and cannot just say that they just didn't know about it, and that may not be good enough. And whilst the structure, quite complex, did kind of display a liability to income tax on part of Mrs. Moran, and whilst she might have said one thing, that the evidence proved otherwise. So the tribunal kind of looked at it overall, through the whole time period, examining the evidence through the whole time period, and they basically relied on the breadth of what can be a benefit under the transfer of assets abroad, and then the burden and the nature of the motive defence, and what one ought to mean by associated operations in this case over time. And this case is important because, especially for those who are maybe possibly looking to raise the motive defence in the future, or are setting up structures, ought to be cautious as to displaying the intention in documentary evidence of what the structures are for. In this case, it was clearly decided by the tribunal that the evidence was not there to suggest that tax avoidance was not part of the setup of this structure. So a good decision, really important decision to read, especially in understanding the legislation around this area and seeing how it was raised. Sort of, I think around 28 pages or so long, so definitely worth reading and understanding and seeing the points that were raised by both parties and what the tribunal made sense of in each point. So yeah, hopefully that was interesting in looking at the transfer of assets abroad regime and these complex structures and how the motive for defence can be raised, how it cannot, and the evidence that might be required to prove raising such a defence. Hopefully that was informative for you all. Thank you very much.